I'm here to provide you training on the California Public Safety Officers Procedural Bill of Rights.
Good. We were expecting you. They are waiting in the briefing room.
Hi, I'm Chip, the Police Officers Association attorney. Today's training is on the California Public Safety Officers Procedural Bill of Rights. These are special rights given to police officers due to the special nature of police work. Let's start with an overview. POBR covers political activity, discipline, privacy rights, and personnel files of peace officers, often called POBR. The law is contained in California Government Code Section 3300. In passing the law, the legislature recognized that police officers are under greater scrutiny than other professions. They stated, "The legislature hereby finds and declares that the rights and protections provided to peace officers under this chapter constitute a matter of statewide concern." The legislature further finds and declares that effective law enforcement depends upon the maintenance of stable employer-employee relations between public safety employees and their employers, in order to assure that stable relations are continued throughout the state and to further assure that effective services are provided to all people of the state. It is necessary that this chapter be applicable to all public safety officers, as defined in this section, wherever situated within the state of California.
Does this law apply to civilian police department employees?
No. The law covers only sworn law enforcement officers, although the California Highway Patrol seems to think otherwise. Let's start with Section 3302A. Except as otherwise provided by law, or whenever on duty or in uniform, no public safety officer shall be prohibited from engaging, or be coerced or required to engage, in political activity. Or be coerced or required to engage in political activity.
My chief says that we are not allowed to run for any office. Can he do that?
Yes, however, no public safety officer shall be prohibited from seeking election to, or serving as a member of, the governing board of a school district. Let's talk about when an officer is the subject of an internal investigation. Section 3303. When any public safety officer is under investigation and subjected to interrogation by his or her commanding officer, or any other member of the employing public safety department, that could lead to punitive action, the interrogation shall be conducted under the following conditions. Punitive action means any action that may lead to dismissal, demotion, suspension, reduction in salary, written reprimand, or transfer for purposes of punishment. The interrogation shall be conducted at a reasonable hour, preferably at a time when the public safety officer is on duty, or during his or her normal waking hours. If the interrogation does occur during off-duty time of the public safety officer being interrogated, the public safety officer shall be compensated for any off-duty time. The public safety officer under investigation shall be informed prior to the interrogation of the rank, name, and command of the officer in charge of the interrogation, the interrogating officers, and all other persons to be present during the interrogation. All questions directed to the public safety officer under interrogation shall be asked by and through no more than 2 interrogators at one time.
You said they had to be notified prior to the interrogation. Is there a set time limit for that?
Good question. In the case of Ellens v. City of Sierra Madre, the Court of Appeals opined that POBR requires an officer to be informed of the nature of the investigation reasonably prior to the investigation, that is, with enough time for the officer to meaningfully consult with any representative he elects to have present. There are exceptions if public safety is at risk. The public safety officer under investigation shall be informed of the nature of the investigation prior to any interrogation. The interrogating session shall be for a reasonable period, taking into consideration gravity and complexity of the issue being investigated. The person under interrogation shall be allowed to attend to his or her own personal physical necessities. The public safety officer under interrogation shall not be subjected to offensive language or threatened with punitive action, except that an officer refusing to respond to questions or submit to interrogations shall be informed that failure to answer questions directly related to the investigation or interrogation may result in punitive action.
Can the officer plead the Fifth and invoke Miranda?
If prior to or during the interrogation of a public safety officer it is deemed that he or she may be charged with a criminal offense, he or she shall be immediately informed of his or her constitutional rights. They can invoke Miranda for the criminal but not the administrative investigation. If she refuses, she can be disciplined up to and including termination. Also, no statement made during interrogation by a public safety officer under duress, coercion, or threat of punitive action shall be admissible in any subsequent civil proceeding. This shall not prevent statements made by a public safety officer under interrogation from being used to impeach the testimony of that officer. For example, if the employee admits to sexually assaulting a subordinate, he can't later lie about it in court, although he might try to do so in a deposition. The complete interrogation of a public safety officer may be recorded. If a tape recording is made of the interrogation, the public safety officer shall have access to the tape if any further proceedings are contemplated, or prior to any further interrogation at a subsequent time. The public safety officer being interrogated shall have the right to bring his or her own recording device and record any and all aspects of the interrogation. Whenever an interrogation focuses on matters that are likely to result in punitive action against any public safety officer, that officer, at his or her request, shall have the right to be represented by a representative of his or her choice who may be present at all times during the interrogation. The representative shall not be a person subject to the same investigation. The representative shall not be required to disclose, nor be subject to any punitive action for refusing to disclose any information received from the officer under investigation for non-criminal matters.
Any representative? Can they use an attorney or a friend?
Yes, however there are some restrictions in addition to the ones already mentioned. In the case of Upland POA via the City of Upland, the officer's chosen representative, the POA attorney, was not able to attend the interrogation due to another matter. This was after the interrogation had already been rescheduled once. The POA sued and the court opined that the officer must choose a representative who is reasonably available to represent that officer, and who is physically able to represent the officer at the reasonably scheduled interrogation. It is the officer's responsibility to secure the attendance of his or her chosen representative. If she is unable to do so, the officer should select another representative. In the case